Hello everyone, this is your host Amir Said and you're listening to the VIVAVISA Podcast by Adhami Law Group. In this episode, we will answer your questions. Questions arise about who can petition SIJS applicants or the age limit for petitioners. We will also discover why your legal status as a petitioner at the state court doesn't matter at all. So, stay with us and let's begin. Hey Kousha.
Good morning, Amir.
Welcome.
I had a lot of caffeine today, so let's do this thing.
Good. Okay, let's begin. We got a bunch of questions and the listeners sent us so many questions. And today episode, we are going to cover 3 or 4 of them, okay?
Okay, let's do it.
Yes. The first question is, who qualifies as a petitioner in the first stage? Mom, dad, family, or non-relative?
Okay, all right. So let me just kind of recap what I previously discussed. So there are 3 stages of the whole SIJS process. First stage is the state court petition. Second stage is the I-360 with USCIS. And the third stage is the adjustment of status or the green card, whether with USCIS or the immigration court, depending on where the child is at the time. So who qualifies for the petitioner in the first stage? It really varies. We really determine this at our first consultation with our client. So it depends who the child is residing with and who is willing to be the petitioner of the child. So if the child is here in the U.S. with mom or dad, okay, and let's just say mom wants to be the petitioner. Now, first, we have to look at the child's age. If the child is under the age of 18 and is residing with mom, then the petition has to take place in the family law court because it's a custody matter. If the child is over the age of 18, okay, and is residing with mom or dad, and mom or dad want to become the petitioner in the first stage, then the matter will have to take place in a probate court. Because once a child reaches the age of 18, family law court no longer has jurisdiction over the child's matter. If the child is residing with a relative, uncle, grandmother, grandparents, cousin, brother, or whatever, it doesn't matter if the child is under the age of 18 or over the age of 18, the petition has to take place in the probate court. Okay, so the probate court doesn't look at the age of the child at that time, so long as they're under the age of 21 years old. Okay, now if the petitioner is a non-relative, that means there is no biological connection between the child and the petitioner. The petition still has to take place in the guardianship court, but the screening of the petitioner will be much different. So the petitioner will also have to get screened by Department of Child and Family Services to make sure that he or she doesn't have any sort of criminal records or anything behind as his background to harm the child in any sort of way, just to make sure that the person is a good fit to be that person. So I've had friends and employers, and I have so many different cases to volunteer to become the child's petitioner. But the child has to be appointed into custody of an individual.
Interesting. It's a little bit complicated.
It's very, very complicated because if you file in the wrong court, your filing may get accepted.
Right,
But then,
right,
But then you
exactly.
go to the hearing, the judge is like, okay, yeah, I read everything. I'm willing to grant it, but I don't have jurisdiction over this case. So your case will be dismissed without prejudice.
Mm.
Yeah.
And then you will lose the time, you know?
Yeah. You lose the time, client's money, so many other things.
Interesting. Okay, the other question that we got is that how old does a petitioner have to be?
Oh, God.
He must be under 21, right? Oh, it's a petitioner.
Right.
Right.
Yeah.
Okay.
Right. So it varies, Amir. And I can see why our listeners would ask this question. Okay, so if we're dealing with in a situation where you have a family law matter, so if it's a mom or dad, it really doesn't matter because the mom or dad are actually entitled to the custody of the child. But this usually comes up when we're dealing with relatives or non-relatives. I think so long as the petitioner is at least over the age of 18, they can accept responsibilities. It should be fine. Average age of my petitioners for relative cases in the probate court have been somewhere between 21, 22 and above.
You know,
Sorry, I didn't mean to interrupt. I guess we just have to, I have seen 18 years old who are more responsible than 35 years old.
right, but it's
Especially
about the court.
Especially in immigrant families, they come here, they start working at a young age, and oh my God, they have their life together like I've never seen it before. Some of them don't even have legal status, but they are so responsible. Something to consider.
Right, but the thing, when you want to petition for someone, you have to have, I think, I'm not sure, but you have to tell me. It seems that you have to have that financial stability to do that, right?
Right.
So what quality the court is looking for the petitioner?
Okay, so before the last hearing, when the petition is filed, there is something called the probate investigation interview. That's when the probate court appoints someone to interview the petitioner to make sure that where the child is living is a suitable place, and also the petitioner is a suitable and necessary candidate. The standard for guardianship is whether the guardianship is necessary and convenient. So that needs to be determined by the court and the probate investigation officer. Okay. So, for example, you have a petitioner, a proposed guardian, who doesn't make a lot of money, but has enough financial sustainability to provide for the child. And the child has his own room and has his own place and goes to school. And for example, in this case, the brother is the proposed guardian. I've seen it. They're so responsible. They come to every hearing and they come to their appointment. They go to school, and schools have teachers have good relationship with the brothers or the sisters. So it really varies, in my opinion. I think definitely they would have to be over the age of 18. But it really varies.
Right, but in future episodes we will cover about the background checks, and we will cover about those things that are related to the petitioner.
Right,
and of course there are lots of questions that we have to answer.
Right,
but we will cover that part for sure in the future. The other question that we have is that about the confusion between an immigration court and state court. Why doesn't the first stage take place in immigration court?
Fantastic question.
It was amazing. Yes.
Yeah, fantastic question, because it causes a lot of confusion. So I have clients who usually are unaccompanied minors. They come to my office and then I explain to them. I'm like, okay, so let me just give you an example. So Mr. X enters the U.S. As a minor, and he or she is immediately placed in immigration court in removal proceedings, right? And Mr. X comes to my office, and Mr. X also qualifies for SIJS. Okay, now I explained to them the SIJS process, and they're like, okay, so we're gonna do our asylum with immigration court. I'm like, yes. And then they're like, okay, we're gonna do the SIJS with immigration court too. I'm like, no. That's the difference. Okay, SIJS, because for the SIJS petition on the first stage, because we are dealing with a family law or a probate/guardianship matter, this issue is solely dealt by the state. The state court has jurisdiction over family law and guardianship matters. Immigration courts are courts of Executive Office of Immigration Review. They belong to federal law, and federal law and state law are separate. So if you want to sue someone that has to do where the cause of action is a federal matter, it needs to be done in a federal court. Federal courts are separate from state courts. That's why when you have Mr. X who entered the U.S. and he's placed in removal proceedings and immigration court, I tell him we're going to be consecutively in two different courts. First, we're going to be in probate court or family law court. And we're also going to be in immigration court. And over time, we're going to get the state court predicate order, and we're going to be done with that court unless the judge has any further orders or provisions for the child that needs to be executed. And then we're also going to be in immigration court because the judge wants to see what's going on with the child's immigration case. And to make matters even a little more confusing, we're also going to be at USCIS for their biometrics, for fingerprint, and even their asylum, because unaccompanied minors who enter the U.S., they can seek asylum with immigration court and with the asylum office, just to make matters even more confusing. So we're going to be at three different stages. Very confusing. Very confusing, very time, it's very time sensitive and very time constraining, So immigration, the matter of SIJS, for our family law court petitions and everything cannot take place in immigration court because immigration courts do not simply have jurisdiction. They're not in the business of appointing guardians or appointing a custodial parent.
Gotcha. So, the first stage is the most complicated one because that's the one that all decisions, everything, even for the rest of the stage is defined over there, right?
Yes.
So it's important. It's not just complaining a form, you have to know how to deal with the different courts.
Yeah, I mean, and in terms of like forms, there's like so many of them.
Right.
Yeah.
The reason that I said that one.
It came to a stage where I had to like even create a checklist for myself, and I've done this for years. I had to like literally, I had to have like a checklist. I'm like, was the GC blah blah was filed, this one, and if you miss one of them, then the hearing's gonna get postponed, or there's not gonna be enough information for the judge to make the findings.
Right. The reason that I said that one, and I guess this is the second time that I'm mentioning this one, because there are lots of like video and YouTube and all of this stuff out there that will tell you how to complete the forms and all of this stuff. It seems it's easy, But when you step in and start to work on it, you figure out, okay, if the court asks you a question and you don't know how to answer the question, you literally will miss all the opportunities.
Right.
And you have to leave this country. You cannot stay here anymore. If you don't know how to complete the form, if you don't know how to come up with the
you're gonna miss
answers.
out on the opportunity to get your guardianship grant.
Right.
You know, it's gonna be very complicated. Or the judge, you're gonna have. So I think.
And then they will deport you, right?
Well, I mean, if you don't do it within timely manner,
Right?
And if you don't get the orders in a timely manner to the immigration judge, then you will be subject to deportation order. Yes.
And for the SIJS, the most important one is that we have to be careful about the time.
Yes.
And the age out.
Yes.
That's
At
the case.
Time, the child doesn't age out, you know, and the I-360 need to be filed as soon as possible.
Great. So to those listeners, please be careful. If you want to do something for yourself, make sure you're not going to mess it up and you're not going to lose your opportunity.
All right.
Okay, the last one. It's about legal status of both child and petitioner. Is it relevant for the court or not?
For which? For the first stage?
For the first stage.
Yes. So the question is, I believe, does the legal status of the minor or the petitioner relevant in a family law or probate court? And the answer is no. Family law courts and probate courts are not in the business of determining your immigration legal status. They're not, you know. Whether the petitioner can be a U.S. citizen, legal permanent resident, an alien with no legal status. Okay.
Really?
Yes.
I thought they have to have a stable...
No.
And okay.
Why would a family law court care about mom's immigration status? Why?
If she's illegal in the country.
So
right?
what? She's illegal. So what? Okay, just because she's illegal, that means she's not a good mom?
No. It's not about that. Okay, that court is looking for that one to understand if she's a good mom.
Child's best interest or not.
Got you.
Mom,
right.
An illegal mom who goes to work, provides for the child, takes her to school, and treats the child like a queen. Why would the family law care about it?
Right. And the thing is that if the mom, I'm sure
and again, I'm sorry, I didn't mean to cut you. And it's just a matter of jurisdiction. The family law court or family law judges are not in the business of determining your immigration legal status. That's the job of the immigration court and USCIS.
So they're not going to report to each other who's who. That's the thing. You know, there are lots of people in this country. They're scared.
Yes.
They're scared to go there, and then what will happen?
That's why I said that in the beginning of my consultation. I'm like, are you a citizen? Are you a green card holder? They're like, no. I'm like, okay, it doesn't matter. So let's move to this. They're like, what? I'm like, does not matter. Let's move on. We're in a family law court. We're in probate court. There's no ICE officers there. There's no immigration enforcement at the family law court. They're too busy. They don't care about that. They really don't.
Right.
It's not in their, they're not in the business of determining your legal status.
And that's the thing that I want to ask the listeners. If you know someone that they have an issue with their legal status, please tell them. There's opportunity for them. If there's a time, if the minor is not over 21 years old, please do not lose your opportunity, and make sure you talk to an attorney to make sure to apply correctly for you.
And one more factor, when the judge makes this, when the family law court judge or a probate court judge makes the findings regarding SIJS, okay, the judge will make the findings that the petitioner is appointed a guardian of an individual, or the child is placed in the custody of the mom or dad, number one. Number two, the judge will make the findings that reunification of the child with his or her mother or his father or both parents is not viable due to abandonment, neglect, and or abuse. And it is not in the child's best interest to return to his or home country. The judge will not and cannot make the findings that this predicate order was issued for the purposes of the child to obtain immigration status. I want you to listen to this, Amir. Very important. If anywhere in the predicate order or in the petition, we're saying, hey, judge, grant this petition so that you can give immigration status, so that my child can get immigration status, that predicate order will be denied by USCIS. I've seen this.
Why?
Because it's a matter of jurisdiction. SIJS petitions are filed for the judge to make 2 or 3 findings. Reunification is not viable and is not in the child's best interest to return to his or her home country. Family law court judges or state court judges cannot make orders that would give immigration benefits. It is up to USCIS to decide whether the predicate order is good enough for the reunification and the best interest of the child. That's the trickiest part of it.
Gotcha. So
you tell the immigration, you tell the family law court judge, Your Honor, I need you to grant this because I want my child to get the immigration status. First of all, the judge should be smart enough not to make any orders regarding this aspect. And if they do, then you're going to have a problem with USCIS.
Okay, Kousha. Based on what I've learned from you, the state court judges cannot make decision for the immigration benefits or the visa or anything like that for the minor. Am I right?
You're absolutely correct.
Okay.
I mean, you nailed it. This is a matter of jurisdiction, okay? State court judges do not have the legal authority to make any immigration status or benefits for the minor. That's up to USCIS or immigration judges. Let me recap. Immigration law is federal law, and every state should follow the federal law, and all states have similar immigration laws. But every state can and have their own laws regarding family law matters and regarding guardianship rules and regulation. They tend to be very similar, but they have the authority to make their own rights because they have jurisdiction over family law and guardianship matters.
Gotcha. Okay, Kousha, we got close to the end of this episode. Thanks for joining us.
I think this one was very, very informative.
Right, it was very
we went
cool.
into details, but that's it really helps our listeners how complicated this petition or this type of petition is. But come to us and we can help you.
Perfect. Okay, Kousha, thanks for joining us, and I want to say thank you to our listeners. I hope you enjoyed and learned from today's episode. Make sure to check out the show notes with the description for access to our website. Also, make sure to share this episode with your friends and subscribe wherever you listen to your podcast. We really appreciate hearing feedback from you, so please share a review for this episode or check out our website and ask your questions. We are located in 21031 Ventura Boulevard, suite number 760, Woodland Hills, California 91364. You can also call us at 213-204-6500. Until the next episode, take care and bye.